Hey, how's it going? All right. What this is a little clip. O'Mara is going after De La Rionda because De La Rionda's been, lying to the court. And he got caught. So they're going to show this to the court. We're not going to be able to see it in this clip because the judge pushes it on to another time. But I just wanted to bring it up and talk about it because I think it's pretty sad that we're at this point where the state attorney is in big trouble. Let's take a little listen to this clip, this part of the clip.
It's going to require some testimony, but let me preempt or start with some of that by stating that we were before you on a motion for specific discovery last hearing, where we asked the state to advise us through the court whether or not they had received any information and any reports concerning Trayvon Martin's phone. And you'll remember that Mr. West was very specific in presenting that motion to you to have those questions answered. He actually twice requested the court for a very focused inquiry in this regard. And you actually asked Mr.
So this is the point where he's telling her what the problem is. Basically what happened is one of the guys that created a report or was part of bringing up a report for the state came to the defense and let them know that the state had this report that was not released to them. In an earlier hearing, the defense had asked the state and asked the state through Mr. De La Rionda whether they had any more information or any more reports, and he said no.
De La Rionda, and he said at first that he had not talked to Selbright and that there was nothing done regarding any information that he'd gotten regarding Trayvon Martin's phone or any other reports. The reason for that inquiry and the specificity for it was that we had just become aware of some additional information in this regard. You then were very specific and asked Mr. De La Rionda at Mr. West's request, did he get any information regarding this phone from anybody? And he said no. We know that to be false. And we have some evidence to present to the court.
So there he is. He very clearly said that Mr. De La Rionda was lying. I mean, you know how lawyers are. They have to make things sound a little better so that you don't want to be rude and say he's a liar. We just say what he said was false, and they're going to prove to the judge that it was purposely false. But it won't be in this hearing because the judge pushes it to another time. She starts the hearing, and you'll see that she has to move it on to another time.
That the state attorney's office received information, gathered information from a report from the Selbright software that they had.
Okay, well, let's go ahead and take the testimony.
Okay, if I might, I'll need a moment to get the witness, Your Honor.
So now it takes a few minutes for him to get it together, and I think it's right about...
He lacks the rules of evidence for this purpose because the witness, as you're going to find out, obviously has some concerns that we'll address. If you would like to recess.
Of course, she's not going to relax any of the court rules. He's asking because they're asking him questions, and he's trying to answer the questions. And in court, it's a little tricky. You have to be careful how you answer a question. You can't say he said or she said because that would be hearsay. They don't allow hearsay in court. So you have to rephrase the question or rephrase the answer in a way that would allow you to make the point without using hearsay. For example, if you had a dispute with a mechanic and you said, I I took my car in to another mechanic, and he said the first mechanic messed up. They would say, well, I'm sorry, we can't accept, that's hearsay, what the second mechanic said. And then you'd say, no problem, Judge, I brought a sworn statement from the second mechanic. Oh, no, we can't take that either. So you have to rephrase the statement. Instead of saying the second mechanic told me this or told me that, you have to explain what the second mechanic demonstrated to you. So, for example, you're trying to say the second mechanic showed you something in the car that was broken in a certain way. So instead of saying the mechanic told you this, you say the mechanic demonstrated. And so now you are the witness to the demonstration of the statement. So it's not really a statement, it's a demonstration. You're allowed to talk about a demonstration. So they go through this little dance, and it's all part of the hearing, and you can listen to the whole hearing if you like. This part comes in at 1:32, 1 hour and 32 minutes, and it's the full Zimmerman hearing, May 28, 2013. So let's listen to a little bit more.
Having some more inquiry we can, but for the purpose of whether or not this court will undertake judicial inquiry as to the discovery violation, I would ask that he be allowed to testify concerning that information.
I would have the same objection, Your Honor. He's talking about hearsay.
It's a court proceeding, and that is hearsay.
As to the timing of the report, Your Honor?
For what anybody else told him.
Okay. Did you then discuss this matter further with your client?
I did.
And who is your client?
So you can see that now he can bring it up in a different way. You can say, did you speak with your client? What did you observe? These are different ways of, bringing it up, and he still has to dance, you'll see.
My client is Ben Kryboss. He's the IT director of the State Attorney's Office for the 4th Judicial Circuit.
And was he working for the State Attorney's Office when this report was created?
Yes, he was.
Are you aware of who that report was given to?
Mr. De La Rionda.
Object to all this line of questioning regarding hearsay. We'll have now an attorney talk about.
Only disclosed to me in this.
So clearly, Mr. De La Rionda is not happy with this line of argument or discussion.
That you would like the court to do this.
I think you could probably get him down here this afternoon. I would imagine he's still, at least momentarily, a state employee. And if you were to request his...
So they're trying to bring the person in that made the statements rather than having this person tell us what the person said. We'll just bring him in. He is a state employee, so they're gonna reschedule for that. Anyhow, the main point of this video was De La Rionda is really in serious trouble. This could be a real problem for him because here he is caught lying to this judge, and there's no doubt about it. So anytime a state's attorney misleads a judge, it's really a bad thing. But when they straight out lie, in the previous hearing, I should probably bring this in, but I'm short in time. She asked him very specifically and more than one time to make sure there was nothing else available for the discovery. And he was very specific. And now you just heard this guy, and he knows who it was given to. It was given to De La Rionda, and he knows now that he's in a lot of trouble. So he's doing everything he can to worm his way out of it, and it's not going to work. So, I don't know what's going to happen with him, and this may be a whole other issue. In the meantime, I would say if the guy is working outside the law when it concerns this case, he has to be removed from the case. He certainly shouldn't be here if he's doing things that are illegal. And we think that George deserves, at the very minimum, a fair trial. I mean, if there's going to be any trial at all, according to the Florida statute 776.012, there should be no trial at all, because the evidence is that it was self-defense. But since we are here and we're going to do this thing, it has to be fair. So anyway, good talking to you guys. Talk to you later. Bye.